We are going to do the next hour or so talking about what it looks like to have first-degree murder charges in delinquency court. We're going to go over the process of delinquency court in general and focus on when somebody's charged with one of these serious charges. By somebody, I do mean a small, young child, our little babies, our children, our youngins. So we're going to talk about secure custody, the authority, timelines, shackling. We'll talk a little bit about shackling. Remote proceedings, we'll touch on that. So you guys can see, some of you that are always in delinquency court a lot, you will know some of the stuff. We've tried to include some tips and strategies that we've heard. One of our favorite things to do is work with you guys when you have these new and interesting things come up, and we make mental notes of all the creative solutions that come out from across the state, and then we take the opportunity to share them. I've already warned somebody in this room I'm going to share a creative solution to something. So and for those of you not familiar with delinquency court, this should at least help to serve as an overview of the process specific to these first-degree murder charges. So then we'll talk about the first appearances. Yes, felonies do have to have a first appearance in juvenile court. Remote proceedings and waiver issues apply there. We will be talking about motions. We'll spend a chunk of time talking about the types of motions that could be brought up in delinquency court. We will talk about probable cause and indictments and all the lack of clarity in the code and gray areas that exist. We'll talk about transfer, the prosecutorial discretion, which we hope could come into play, but we recognize, of course, with first-degree murder charges, they don't always come into play. But just in case you have that case and you work it just right, Dustin, then we'll get to the remand, adjudication, disposition parts of what could bring something back into delinquency court. So you guys probably saw these out front while you're registering. Some of our resources. These are quick guides. I don't have our brand new red one on there, the first degree murder one, but just as a reminder, we try to come up with as many different ways to give you guys resources as possible. And for those that like to have that thing in their hand, boss, the paper people, we've got the paper versions, but we've also got the electronic versions online. Okay. There we go. Custody, right? This is when, for the most part, this is when we get involved in a case as defenders. Your child is already in custody. Ideally, you might be able to get involved beforehand, but majority of the time they're in custody, and that's when you find out about it. With the roster process, once a child has been charged, then the appointment process happens there. So realistically, this is where we're starting. There are three different types of custody: temporary, non-secure, and secure custody. Temporary custody is under 7B 1900 and basically says this is the type of custody that a child can be held under until a court order is obtained. And this is a minimum of 12 hours in custody, 24 hours if it's the weekend or a holiday. There are very, very limited circumstances that this temporary custody can be used. It's basically by law enforcement or the court counselor if they have reasonable grounds to believe a youth is undisciplined or absconding or something to that effect. Temporary custody, and law enforcement can use it when there's basically probable cause. So that could come into play with your first degree murder charges. Non-secure custody is under 7B 1903. That is the runaway child, or if for some reason it's in the best interest of that juvenile that they be in non-secure custody. So typically that's DSS. We can get creative and find other ways to do non-secure custody, but that's somebody other than their parent, but not behind bars. Secure custody, 7B 1903. This is where we're going to see it with our kiddos charged with first degree murder. There are statutory criteria for holding a child in secure custody. It can happen pre-adjudication, it can happen pending placement or disposition. It could happen for probation violation potentially, or if a judge says for whatever reason, transportation, a child might have to be put in secure custody for that. Realistically, we're talking about pre-adjudication stage, like this is the adult equivalent of, I can't curse, can I? My kid's arrested, right? Secure custody. Once I start, I don't stop, so.
You're in good company.
Yes, that's true. I am a type bet, yeah. Oh, let me not take over Terry's part.
So secure custody, there is statutory authority for who can place a youth in secure custody. It's under 7B 1902. And that statute allows any district court judge to place a juvenile in secure custody. They can delegate, so your chief court or your chief judge can delegate to the chief court counselor or their staff by an administrative order. So if you get a secure custody order and it is not signed by a judge, check and see what your administrative order in your particular county says, because that administrative order must identify which persons can be contacted to approve a secure custody order. And that administrative order has to be filed with the clerk's office. So if you have somebody who is not authorized to sign for secure custody, that might be an argument you can make to get your child out of secure custody. If you are in a situation where your case has already been transferred to Superior Court, but you are lucky enough to have it remanded back to district court, the Superior Court judge can issue a secure custody order on remand. So for secure custody hearings, we do have the initial hearing and review hearings. Under the initial hearing, that is to take place within 5 calendar days of the child being placed in secure custody. If it's under delegated authority, so if it's been signed by a magistrate, if it's been signed by a court counselor, then it has to be at the next session of district court. That initial hearing cannot be waived and it cannot be continued. So when you're in the courtroom and your judge is asking you, will you waive secure custody, or your DA is pushing you and asking you to waive secure custody, you cannot waive the hearing at the initial hearing. For review hearings, it's a little bit different. They take place within 10 calendar days of the prior hearing. They can be waived with the consent of the juvenile and through counsel, but those waivers can't be past 30 days. So if you do have a youth who's in secure custody for a high level offense, and for whatever reason you make the decision to waive secure custody, you can only waive it for 30 days. So after 30 days, or at that 30-day mark, you have to have another hearing or be in the courtroom saying we're prepared to waive for another 30 days. If you do have a 16 or a 17-year-old charged with an A through G felony, theirs is a little bit different as well. So they can have their review hearings within 30 days. They don't have to do 10 days. So if you're arguing for a hearing within 10 days and your kid is 16 or 17, the ADA is probably going to be arguing, no, we need to set this out 30 days because we're going to indict this kid. We've already got the grand jury lined up. You can still argue for the hearing to take place within 10 days if there's good cause. So if you got short notice, you're just blindsided, walk into the courtroom and told, here's your kid, you gotta have this hearing because so-and-so withdrew. That might be good cause. If you've got a family member who is coming from out of town willing to take placement of your kid for a short period of time or for a longer period of time, but that person's not there yet, that might be good cause. If there's mental health issues, there's nothing clearly defined about what constitutes good cause. It's basically your judge deciding that it's good cause, but argue for those earlier dates anyway. You can waive those hearings as well through counsel. The youth can waive through counsel, but again, you can't waive beyond 30 days. Remand, again, is a different section of the statute. If your kid is remanded to district court, and the Superior Court judge issues a secure custody order on remand, you have another initial secure custody hearing. It has to take place within 10 days of that remand, and it likewise cannot be waived or continued. So we have statutory criteria for secure custody orders if you are pre-adjudication. So when you're arguing in court to your judge about why to release a particular kid, it is reasonable factual basis to believe the offense alleged in the petition is true, and one of the following factors exist. So both of those things have to apply. So if you've got a Class A first-degree murder case, obviously the state's going to be arguing charged with felony and has demonstrated a danger to person or property. We're encouraging defenders to argue that just because a youth is charged with a felony does not mean that they are necessarily a danger to person and property, because you are still presumed to be innocent. So you need to be looking at and arguing, what does the prior record look like? What are this kid's circumstances? If they've never been in trouble before, then there is no reason to believe that this child is a danger other than the specific charge before the court, which we know they have to be presumed to be innocent. So make those arguments. If they are alleged to be a danger to persons and they are charged with a misdemeanor with at least one element of that misdemeanor being an assault or use of or commission of a crime with a deadly weapon or a DUI, that can lead to secure custody. And then of course we have willful failure to appear in court. They have to have notice. So if you've got a kid who has been charged with first-degree murder or some other related felony and they don't show up to court, check to make sure that there's notice, because clerks will tell you that there's a proper notice, and then you look at the clerk's file and the court file and you see only the parents were served. Kid wasn't. That's not grounds for a secure custody order, so make sure you're checking that. If there's cause to believe the juvenile will not appear, this is typically when you have a court counselor who is arguing, this kid has been a runaway, they've missed school, they've got all these issues. That's different from being absent from court. So make sure you make that distinguishing argument that just because this kid has run away from home where there are obviously problems with mom or dad or DSS involvement, that doesn't mean that the kid is a risk to not appear in court, especially if the kid is standing right beside of you whenever the request is being made for them to be placed in secure custody. The others are pretty self-explanatory. Absconder from a residential facility or for the juvenile's own protection. The own protection ones, in that specific set of circumstances, you have to have a juvenile who has attempted or has inflicted self-inflicted injury of some sort, and they have to have been denied admission to a hospital, at least one hospital. If that hasn't happened, then that's not an appropriate ground. The last two, you're not likely to see if we're talking first-degree murder, because those are for undisciplined youth, so the likelihood of seeing those is very small unless you're actually practicing in juvenile court. Just know that those do exist.
Quick question for you guys. How many of you are in a jurisdiction where your judge likes to conflict the has demonstrated that they're a danger part with the charge with something that's dangerous? We're doing it, right? We're working on it. So you're in good company. There's another one that you're in good company. So keep up the good fight. Remind your judges this is something other than, somebody said it earlier today. Was it, well, it's either Dustin or Dr. Cottle, just because they're charged with it, like, right, that Constitution thing. What? The Constitution, right? Innocent till proven guilty. Like, they're not guilty of this thing that they're charged with. So what is the danger that you're talking about? Right? So you're in good company if you're facing this battle as well.
Eric's taking credit for that one, by the way.
It was him.
Was that Eric? Oh, I'm in so much trouble now. Sorry, boss.
I think that's when he volunteered to be our expert witness to our judges that the Constitution does apply in district court.
It does, in fact. Yeah. So, and the willful failure to appear, we were talking about, you know, kids like a 13-year-old, they don't drive. They're not, are we expecting them to use public transportation? So if mama's not here, mama doesn't want to show up. How are we going to say that this kid is willfully failing to appear? So there's a lot of room for argument. All of this, the crux of all this is you got to know your kid, you got to know the situation to be able to make these arguments, because it's like, hey, be in court in 15 minutes and go, right? So.
So I will say, if you are in an area where you have a 15-year-old who is also charged with theft of any kind of an automobile, your judge is probably going to say, yep, they have the ability to do this, so they've got the ability to get here because I think that got shot down. So just know that that's an issue.
Know your judges.
It is the state's burden to prove reasonable factual basis to believe and that one of these factors exists. State sometimes likes to come in and just read from the petition and say, this is a serious charge. I mean, look, it's an B1 felony, it's an A felony, because clearly it's right here. It's all in the petition. That's not good enough. Make them put the officers on the stand, testify if necessary, because you need to have that reasonable factual basis. And it's honestly, some of those hearings are a little bit of a preview of what your PC hearing is going to look like. So you can get some valuable information there. In some areas, officer might come and testify to one thing at the secure custody hearing, and by the time they hit PC, they're saying something completely different. Those hearings are all recorded, so use it to your advantage. Okay, so post adjudication, your kid has been sent back to juvenile court. They've been adjudicated of a lesser offense, and now we have to look at whether or not they are going to stay in secure custody or be ordered into secure custody. In fact, that can happen pending placement. So if you've got a kid who has been recommended for a residential treatment facility, that could be an issue. Pending disposition, and if you have a child who is charged with a probation violation, if there was damage to property or persons. So probation violations are limited to that specific set of circumstances. If your kid has been adjudicated, I'm going to backtrack a little bit because the slide's a little bit off. If your kid has been adjudicated of a probation violation, yes, they can get double the amount of time in detention for that. But if it's on the front end, they have just been charged with a probation violation and they have not been adjudicated yet, they can only be placed in secure custody if they are alleged to have damaged property or injured a person. For first-degree murder purposes, that's mostly going to be your remand cases. Shackling, handcuffs, ankle cuffs, chains.
And this also brings up, I'm one of the people that likes to use imagery when I talk, and if you haven't already thought about the racial disparity that happens in our courtrooms and the imagery that went with that, so the probably don't have the time to get that today, but it's that you really figure it out. The whole lot of people about it. You have to practice. Yeah, a little bit more on my. Still let it go? Yeah, still let it go. Turn it off and turn back on. I'm just turning it off. Okay. I've been given permission to cuss. Nope. Boss gave the eyebrows.
All right, I will continue to project, and if you guys need me to project more, I'll just keep projecting more. I've got lots of hot air where this comes from. All right, but shackling, right? Like, we are putting children in handcuffs. We are putting them in ankle cuffs. That's not okay. What is the tagline on your email? Do you remember it off the top of your head? Because I smile every time I see it, but I don't know if I can. It's at the very bottom.
A measure of a society is how they treat their children.
A measure of a society is how we treat our children. And in North Carolina, we like to put them in handcuffs and ankle cuffs and shackles and chains and bring them into the courtroom. Not us. We fight against that. Here are the tools that we offer to you to fight directly in your courtroom. The statute that even allows for these things to be on their ankles and wrists is an only when statute. Only when it is reasonably necessary. 3. I should have put 1, 2, 3 instead of bullets. 3. There are only 3 reasons you can put. You can bring a child into a courtroom with these shackles on. To maintain order in that courtroom, to prevent that juvenile's escape, or to provide for the safety of the courtroom. There are 100 different justice systems across the county, 100 different courtrooms, and I could probably think of, I'm not very good at math, 500 different ways. Yes?
Sorry. Is maintain order, is that open to opinion?
He said, is maintaining order open to opinion? All in unison now. 1, 2, 3. Yes. Absolutely. That's exactly where we're going to have our arguments. What is order? What is have to keep myself under control here. We're Kelly, where are you? There you are. Okay. Kelly and I are knee deep in examinations of a certain county. And we're comparing. There's an interesting sort of pattern of language that comes from the judge in this county that, for these reasons, da, 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 da. And one of the ones that I was watching, she started reciting the reasons why the child should be brought into the courtroom with ankle cuffs, and then stopped and realized the child was not even in custody. So part of our job is to know our culture, know what we're fighting against, and how to do that. So 2402.1 allows the judges 3 reasons to put those shackles on that child. The defender has to have an opportunity to be heard. So that was another interesting part of that situation. The defender was walking up to the table while the judge was making these findings about courtroom security. Her opportunity to be heard was, Judge, my client's right here. And your judge has to put findings of fact written in the order as to why they think this child should be in custody. So in your jurisdiction in particular, if you feel like this is happening and you have an opportunity to compare the findings of fact across different children, then maybe you find a pattern. Lots and lots of room to advocate here for your child. Okay, remote proceedings. What did we decide about this one? That 7B is remanded. Okay. All right, so Eric talked earlier about 7A and 7B, 7A being the A&D part of the code, and then 7B being the delinquency part of the code. The remote proceeding statute is actually under 7A. They're allowed, but the court has to, let me just read this so I don't say it wrong, must obtain a knowing, intelligent, and voluntary waiver when the right to be present or confront and cross-examine witnesses is implicated. The right to be present is like what, 100% of the time? Mm-hmm. At least according to us. I know some of our judges don't think it's like 100% of the time, but this is something that we won't harp on too much, but when you're having multiple secure custody review hearings, your judges are going to say, well, can't we just do this on video? Can't we do this on video? It's a strategy decision sometimes, but
If you can get them to call AOC, which happened in my counties, AOC's telling them, no, you can't do that without a waiver. So if they're arguing with you and telling you you have to put a kid on a remote hearing, tell them to call AOC and ask to speak with somebody about that issue, because just within the last 2 weeks, that's literally happened. And the judge was told by the person that answered the phone, no, you can't. Here's the statute. This is how you're supposed to do it. So just know that you do have a way to get around that if your judge is really pushing.
okay, let's switch gears just a little bit and talk about first appearances. I like how that graphic worked. Looked pretty cool. First appearances are required only on felonies, not on misdemeanors. They must be held within 10 days of filing the petition. It must be held either at the initial hearing, if your child is in custody, which in this situation, most likely, or if they're not, that first appearance can be continued. Again, a strategy decision on your part if, yes, question.
What you mean within 10 days of service on the juvenile?
In the ideal world, we like to think those things happen about the same time, but yes.
Can you repeat the question, please?
Oh, yes. Did I not mean to say within 10 days of service on the juvenile? Yes, right? And I'm saying in an ideal world, that's basically the same thing. You do the petition, you go ahead and get it served on the child. Realistically, that's not how it works. So yes, I do. Thank you. And as part of this first appearance, the judge is required to inform the child of the allegations against them, their right to counsel. Remember, we talked about the fact that they're indigent. They cannot represent themselves despite being charged with the worst of the worst, especially since they're charged with the worst of the worst. their right to a probable cause hearing, and the judge also has to go over with the parent the jurisdiction that they have over the parent, at least while the case is still in delinquency court. Oh, I have the one more thought on there. The AOC form, if you guys have seen the AOC form on the first appearances, there's not a spot on there that says what the child was advised on for their first appearance. So if your child has multiple felonies charged separately, it's going to get real interesting trying to figure out which one of those first appearances was for what, to the point of you might have to go back to a recording or something. But because first appearance triggers other timelines, I don't know. It just gets real interesting real quick. All right.
So for those timelines, for your first appearances, that brings us to what motions do you file in juvenile court? What motions might you file in superior court? And largely, these motions are going to be the same type of motions that you would file for an adult client. So the very first one that we're going to talk about is discovery motions. We do have a juvenile statute that covers discovery. You are entitled to discovery in juvenile court even for misdemeanors, so it's a little bit different than the adult system from that respect. It is very similar to the language for adult discovery in that upon a motion, the court shall order statements of the juvenile to be turned over to the defense, names of witnesses along with copies of the record of witnesses under the age of 16, and documents and tangible objects that are material to preparation of defense, intended for use as evidence or obtained from or belong to the juvenile. So your juvenile cell phone was seized and a cell phone dump was obtained. State's got to give you that information or give you access to the phone and an expert to maybe look into those types of things. And then they also have to give you reports of examinations and tests. You do need to know that the discovery motions trigger reciprocal discovery rights, just the same as they do in the adult system. And that the state does have a right to the names of witnesses that you intend to call. A couple of differences from the adult statutes. There's no written voluntary request requirement before filing your discovery motions. There's no statutory rights attached to voluntary compliance, and no timelines. So the adult timelines based on PC hearings don't comport with PC hearings and the statutes that we have in juvenile court. But just be aware of that, because you may have your client in court for the first appearance, and then they're 16 or 17 charged with Class A felony. State's got 90 days to make a decision about indicting that child.
I have a question for the room. Has anybody run into an issue where you filed your discovery motion in district court, in juvenile court, and then it's been transferred, and then you run into any kind of discovery issue? But I'm most curious about the requirement that your discovery request be filed within X amount of time of the indictment. Has anybody come across that? Cool. Please let me know if you do. I'm super interested to see what happens if that ever comes up.
So the next motion that we thought would be important to talk about would be motions to suppress. Likewise, we have a statute 7B2408.5 that speaks to suppression issues. That statute is specific to adjudication hearings, but it does apply to probable cause hearings. So you just need to know that you can file or make a motion to suppress before a hearing starts. But if you do that, it has to be in writing and must be accompanied by an affidavit. Don't forget your affidavit. If you need copies of motions to suppress and an affidavit, we do have those on our website. It can be in writing or oral if you're doing them in the context of the hearing or in the confines of the hearing. So the judge can summarily grant or deny those motions, or have a hearing and make findings of fact and conclusions of law. But your denial of suppression motions can only be reviewed when there's entry of a final order. So you can't appeal suppression statute 15A9 does apply, so you will look at both statutes when you're making your motions to suppress. So the case law that we use in these suppression motions, and if you look at our website and you pull up one of the suppression motions to see These three cases in particular cited fairly often. So Miranda versus Arizona, everybody I'm sure is familiar with that one. Police interviews are inherently coercive, more so whenever you have a child involved. Pre-interrogation warnings have to occur, protection of your Fifth Amendment rights. And then in re Galt, extended due process to juveniles, including Fifth Amendment privileges and Miranda warnings. We obviously have Miranda warnings that are a little more extensive for juveniles because a parent or a guardian has to be present, or they have to be advised of a right to have a parent or guardian present during custodial interrogations. And then if you haven't read it, JDB versus North Carolina, age is relevant to Miranda custody analysis in juvenile court if the juvenile's age is known or objectively apparent. Majority of the time, the juvenile's age is going to be known or objectively apparent because these are kids. Physically, you can look at them generally and tell that they are younger. Most of the time, one of the questions the officer is asking them whenever they first approach them is, how old are you? So the majority of the time, this is going to be something that is known to the officers.
2405, conduct of the adjudicatory hearing. I want to point out that there is some really powerful language in there that you guys can reference if you're having one of those moments with a judge that you can't use the words you want to use. So you use the statutory words instead. The court shall assure due process of law for the child. Right? So we've got Galt saying it, but now we have North Carolina statute saying it. They get due process, darn it. And they shall protect, right? You knew what word I was really wanting to use there. They shall protect the juvenile's privilege against self-incrimination. The statute has all of those rights actually spelled out, but that one in particular, and it's a shall protect statute. Our case law says this, our statutes basically say this. Our children are in need of it, deserving of a higher level of protection by the courts than adults. And just because they have been transferred doesn't make them not a child. So you can use a lot of this language even after it's been transferred to construct some of your arguments. We actually have a specific suppression statute for, say that one 3 times fast, for juveniles, for kiddos, for interrogation procedures. And there are some obvious and some nuanced differences for how a child can be interrogated versus adults. So obviously they do have to be advised of their Miranda rights. A parent or attorney must be present if the child is under 16, and the parent may not waive any of those child's rights. It's the child's decision. That goes back to an interesting discussion about capacity and what Dr. Cottle was saying about, well, are they actually waiving their right, or are they just trying to get the right answer to get out of there? And is that, so whole long discussion. But it's in there that at a minimum, it's got to be the child that says it, which I don't know if that helps or hurts. Could go both ways. This is actually one of my favorite parts of this statute. Subsection C says, if the child indicates in any manner and at any stage that they do not wish to be questioned any further, then questioning shall cease. That is much more specific than the adult statute. Actually, it's much broader than the adult statute. Anything at all, anything. It's not like, you know, as adults we're articulate. Some of y'all are articulate, well-spoken. And please, sir, I do not wish to be questioned any further. That's pretty good. These are kids, and this statute says, listen, any attempt by these kids to say I'm done is I'm done. So keep that one in mind if you're going through. I just watched Discovery on One where my kiddo was just like, I don't know if I want to do this. I'm like, I got an argument. Let's go. And then finally, the court shall find that this child willingly, knowingly, and understandingly waived their rights if they did, which law enforcement is always convinced they did. In re KDL, I'm not going to read this entire slide. I would not have the voice for it. Plus, it's in your notes, but we have a whole bunch of great language in there. ultimately, in regards to suppression, a student is not in custody. So we're talking school law here, unless he is subjected to additional restraints beyond those generally imposed during school. So the fact that they have to go to school and they have to go to their class and they have to do this and have to do that, while they may feel like that's custody, because I remember my teenage years, Dr. Cottle, I felt like that was custody. In the legal sense, it needs something just a little bit more than that. But as defenders, we're going to find that something more. That officer that walked up and said, "Come with me," and he's in full uniform and has his hand on his holster or whatever. And then there's like another officer, and is this school or where are we now, right? So those are the arguments that we're making. JDB versus North Carolina. Eric has talked about this. Terry has talked about this. There's some of that fantastic language in there. Children are not adults. I feel like that's all that we really need to say today. Children are not adults. In re DAH. My favorite thing about this case is that it spelled it out, black and white, two-prong test. We like that as attorneys, where it's like checkbox, 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 easy to follow. So if you need something that goes into school interrogations and shows how to do a good balancing test, check out In Re DAH. I totally took over your slide.
She was on a roll. I wasn't going to stop her. So we've already talked a little bit about records and experts this morning. So hopefully you were paying attention whenever Dustin was talking about getting DJJ records and 7B 3000 and 7B 3001. When you get appointed to your kid, one of the very first things you need to do is start looking for their records. Their Department of Juvenile Justice records, their DSS records, medical records, mental health and school records. All of those things, they're relatively easy to access, but you need to be making the appropriate steps in that direction. So if you've got a parent or a guardian who is very involved, very appropriate, and is doing what they can to help the child, it might be really easy for you to get those records just by saying, "Hey, go sign these releases for me. Bring me these records," so you can sort of start working and see what's in there. You might need subpoenas in order to get some of these records. 7B 3000 and 3001 are very specific, and they say that you are entitled to your client's court records and to their DJJ records without a court order. That doesn't necessarily mean they're going to be turned over easily. Some districts turn them over very easily, and some of them will argue tooth and nail that you're not entitled to them because the case hasn't been adjudicated yet. We do have a motion to obtain DJJ records if you run into an issue with that, but by and large, I think that issue is starting to be cleared up statewide, and that it's pretty easy now to send a request and just get all of those records. You are going to need those records whenever you make those motions for your experts, because the experts want those records. They want to see what was the prior involvement. Was DSS involved? They're looking for history of past trauma, any past medical diagnoses or mental health diagnoses, and those records are a wealth of information for purposes of your experts, as well as for building your case later down the line for mitigation. So capacity to proceed, I'm not going to cover this in detail because it's already been covered, but it is basically the same as the adult process. You need to ask for, we encourage people to ask for your expert's ex parte, because obviously you don't want the DA to have all of the information that you have. I don't know about your districts, but I have gone and asked for an ex parte request for funding and then had my judge turn around and blab the whole thing to everybody in the courtroom. So it really was kind of undone by the judge, not because of anything being sealed in the file. I agree with Dustin on the issue about don't let it be sealed in the court file, because if it's sealed in the court file, anybody that looks at that court file knows something was done. Here it is, it's sealed in here, and there's only a handful of motions that you're going to file and have sealed in the court file. So if you have it sealed in your own file and maintain it until the case is over, that's going to be far better for your client.
Question, who all's in a E-Courts pilot county? This gets even more fun when this is e-courts. It's one thing when you know your prosecutor's too lazy to go and look and it's like just by chance they might see it. But e-courts comes around, oh, I'll keep you posted. Yes.
I think I
yes.
sent out an email for expert funds. You can send an email with your motion, if you do the motion, the AOC form, directly to the judge's assistant or the TCA. And I sent out the email with their email addresses. I've checked for district court for juvenile with Judge Mangum. We're good. And then for Harnett, Lee, and Johnston, they're all the same. Judicial district, I spoke with Chief District Court Judge Wood. So in those counties, just email it to the TCA or it's Miss Gabby in Lake County.
Will you stand up for a second?
No.
All right, go.
You guys, this is Kevin Boxberger. You've seen his name and now you see his face. So thank you, Kevin, for helping all of us figure all of this out.
You're welcome.
Okay, so some other motions that you might file either in juvenile or in superior court. Speedy trial motions, there is no specific right spelled out in the juvenile code for speedy trial, but juveniles do have the same rights and protections as adults. So you can argue that whenever you're making those types of motions. Obviously, experts has been talked about. Venue motions, we do have a venue statute in the juvenile code. It's 7B 1800. The only thing that you need to pay particular attention to there is that it does say very clearly that adjudication shall take place where the crime is alleged to have happened. So if you were thinking about filing a motion to change venue, that might be more successful in superior court than if the case is still in juvenile court, unless you have gotten to disposition, and then there's some different provisions that apply at that point. Jurisdiction, summons, and particular defects. Pay attention to your petitions and pay attention to your summons. So in the juvenile system, we have summons, not warrants. So you need to look at those and make sure they haven't expired before the kid and the parents were served. Obviously, the DA can just dismiss and refile if that's the case, but do look at it and see if there's an issue there, because sometimes if it's a low enough level offense or if there's difficulty with the victims or the witnesses, if you've gotten it dismissed the first time, maybe they'll make a better offer the second time. You do want to look at whether or not those petitions are legally sufficient, the same way you would for a warrant, and consider any arguments that you have about fatal defects and fatal variants whenever you're looking into all of the information that's been provided to you. Motions to dismiss. Juvenile petitions are notorious for alleging second-degree murder. They'll mark it as first degree. They'll have Class A offense on there, but the actual language of the petition is the language for second-degree murder. So take a look at that. Look at it very closely, because you may be able to file a motion to dismiss based on that. We do have some motions available. I think those are on our website. If they're not, I have copies of them. Yes.
So weird question about these blended start in district court but go to superior court petition issues. Obviously, we have short form indictments in superior court for murder, but we don't have those in juvenile court. Is there an argument that because it originates in juvenile court, they have to plead the indictment as they would the petition, or is there anything there that we can borrow?
Let me rephrase the question so this side of the room can hear basically, but she's asking what can we do because the short form for in adult court doesn't match up with how we have to do it on petitions. What is the argument for saying that because it's required for petitions, it's required after it's transferred for indictments? Did I say that correctly, Ish?
Yes, and or are they tied to what they petitioned for proof? So if they only allege for
Okay.
P and D, can they be precluded from seeking felony, I guess? I don't know.
Okay.
Can we make some noise with that, is my question.
Here's exactly the opportunity. Everybody take your hands, go like this. Let's make some noise for that argument. Yes. We're gonna try that again. This side of the room. Take your hands. Everybody help them out. They need help on this side. Take your hands, go like this. Yeah. Also, I just needed to wake you up after that lunch coma you all gone into. Thank you.
So the short answer to that is yes, you can make those arguments. There is a case, and I can't remember the name of it, that is not great for us on those specific arguments. But David Andrews with the Appellate Defender's Office is really good at helping argue those motions, so I would encourage you to contact us. Yes, Eric?
And I'm sorry if you're gonna get to this, sometimes we forget to talk about it. So it's an uphill battle a little bit with what you're charged with in juvenile court and once they transfer it. Because once they transfer it, you know, it's, what is transferred for the purpose of indictment in adult criminal court is anything related to that offense. So even if you've got a good argument, unfortunately, that an alleged second-degree murder, and you win it, and it gets transferred as second-degree murder, they can still indict it on first. That's an important thing to know and to be aware of before you go up. And sometimes we don't think about that, but that is how it works. And so you gotta think a little bit more about, is there a way we can defend against that piece, sort of thinking the way Kelly was thinking about it. But right now, the statute says it doesn't matter what was actually transferred. You can indict on anything that's related.
And that's accurate, but it's anything that's related. It's not the unrelated misdemeanors and all of the other things that were on separate dates of offense. So be careful about that, because some ADAs are looking at it and saying, well, we indicted this, so we're taking everything up. If it was different date of offense, totally unrelated, look at the lapse in time, you may have some arguments there that you can make as well. So other motions to consider: amendment of petitions. You cannot amend a petition in juvenile court if it changes the nature of the offense that was alleged. To make sure that you're paying attention to that whenever you're standing in the courtroom and you have a DA who's asking to amend a petition, even if it's some small amount of language, if you think that that changes the nature of what's alleged, argue against it, because the statute is very clear on this that you cannot do that. Bill of particulars, that's more of a constitutional argument. We don't really have a statute that covers that, but just know to make that. And we didn't cover this earlier, and I didn't include it in the slides, but along with your discovery motions, you should be filing the same motions that you would file along with that for adults, for preservation of any evidence so that it's not disappearing on you later.
I'm not hating how much time we spent on motions, because that's a huge important part of these, but we're gonna fly through the rest. All right. Probable cause and indictments. We've already talked a little bit about the indictments as it is, but basically all felony cases ages 13 and up have to have some form of probable cause, whether it's the hearing or indictment. It has to be within 15 days of that first appearance or 90 days of the first appearance if they're 16 or 17, right? That's where we get back to that thing I was saying about, well, which first appearance are we talking about? It can be continued for good cause. You may not want there to be good cause, or you might. You can waive it in writing. And non-hearsay evidence is admissible, or if there's, reports are admissible, and then also exceptions to the evidence rules. Now, if the judge finds that there's no PC for that felony, Justin, then they can dismiss it, or they can adjudicate on a lesser included misdemeanor. And the statute does specifically say that it shall be a separate hearing, right? So if it, probable cause, beyond a reasonable doubt, not the same thing. Yes.
So when you waive probable cause, not that I've ever done that in 12 years, but when you waive probable cause, does the judge still have to enter an order finding that probable cause is present?
Why, yes. Yes, they do. Oh, too many war stories, Okay, indictments, same thing, except these are only applicable to children 16 and 17 years old charged with those A through G felonies. No indictments on 15-year-olds, 14-year-olds, or 13-year-olds. If you have a 14 or 15, whatever year old charged with first degree murder, and then the prosecutor tries to bring down an indictment, say we're going up, you say, no, blank, no. That's not how it works. In fact, you say, and now I have a motion to dismiss, Your Honor, because you have brought forth evidence that however many people have decided this about my child, and I'm moving to dismiss this case. So no indictments for the younger children. was like, what did I mean by that? The prosecutor can choose to do an indictment in lieu of the probable cause hearing for these children. Consider that motion to dismiss if there is in fact an indictment that came down. And this is a good spot to remember that first degree versus second degree argument or consideration, I should say. You know, does the petition match the indictment? You know, all this conversation we were having just a minute ago. Yes?
If you have a PC hearing, on first degree murder, and the court finds no PC, can the state still bring an indictment?
They sure want to try, right?
Can the state bring an indictment?
Yeah.
Yes. I don't think it prevents them from doing that. But just be aware, I don't know why they would go that route, but you know, stranger things have happened, so they can do either.
That's gonna be my motion to dismiss if they try to do something like that. All right, so speaking of transfer and prosecutorial discretion.
Okay, y'all can read this slide for yourself because we're short on time already. So we're gonna skip it because that's just the ages that transfer hearings. Your DA has to give you 5 days notice of their intent to transfer the case to Superior Court. Mandatory transfer, you have to have notice and either indictment or a probable cause finding. Discretionary, you're looking at whether or not the protection of the public and the needs of the juvenile will be served by transfer. And of course, we've got 8 factors that have to be considered there. If you look at those 8 factors, I'm not going to read them all off because again, we're short on time, but they mirror the language of the Miller factors for Miller hearing purposes. They also are very similar to the mitigating factors in the adult statute. So just pay particular attention to those because the judge has to make findings about each of those 8 factors and whether or not they have considered those. So for transfer purposes, you are going to want to consider arguing constitutionality of mandatory transfer schemes, weighing your client's interest in doing so. You do need to know that if transfer is ordered, discretionary or mandatory, a great case for defenders. The Court of Appeals kind of messed up and conflated probable cause and transfer as the same hearing. They are not. They are supposed to be 2 separate hearings, but in doing so, the court said that in order to preserve the right to appeal this issue, regardless of mandatory versus discretionary, the defender has to appeal the issue to Superior Court and have a hearing, and they applied a de novo hearing on those issues. So you can use State v. Wilson to get to Superior Court and have another hearing on that transfer issue based on State v. Wilson. State v. Garrett, again, not favorable to us. It shot down a lot of the constitutional arguments that defenders were making, but in State v. Garrett, that youth was charged pre-raise the age when the statute was very different. So because of those statutory distinctions that exist now, we are still asking people to consider appealing these issues and make arguments in the lower court about precluding mandatory or discretionary transfer for your kids. That brings us to adjudication and disposition hearings if you are lucky enough to get your case remanded back to juvenile court.
Essentially, all you really need to know, I want to say all you really need to know, because we're all aiming for this, and we're 100% going to get an A back down, and you're going to do this at some point, and then you're going to let me know, and we're going to throw you a party, and I'm not really being that sarcastic about it. But upon joint motion, the Superior Court shall remand, Dustin, we talked about this one too, to district court, right? So it's a shall. The judge doesn't get a say so after everybody agrees. The key is getting everybody to agree. The Superior Court record does get expunged, but that judge may issue order for secure custody. This is a really good opportunity to talk about talking to your Superior Court ADA and saying, hey, look, this kid is going to get better services and better rehabilitation, and it's going to be better for society if we're in YDC instead of prison, right? And so I want to pick on Mary Wilson here for just 1 second. Will you share with us what you did that one time that had that success that everybody could draw from?
I'm as loud as Marcia, so I don't need a mic. I had a B1 sex offense, and they indicted it immediately and then realized there were problems, so we started talking. Assume your ADA in Superior Court doesn't know anything about juvenile court and even knows less about juvenile services. So I did up a comparison of the treatment he would get in YDC versus the treatment he would get in Foothills, which is where they send 16 to 21-year-old kids sent to prison. And treatment in YDC was a long list, including a full psychoeducational, access to teachers, access to IEP special ed teachers. If he gets a GED or a diploma, access to community college, restorative justices practices where they would teach my kid about empathy for the victim and why he shouldn't do this again. And in Foothills, there was none of that. There was a possibility of getting some classes at the local community college, no individual counseling. He could request mental health services if he asked for them, if he said I'm depressed, but he didn't automatically get all that. When I sent that to the DA, he went, and I argued that you'll protect the public more if you send this little rapist to treatment rather than to prison. And he agreed with me and remanded. So it works.
Know your prosecutor, know what their buttons are. They're all afraid of the Victims' Rights Act. We don't have any prosecutors, right? Okay, great. So, whatever their buttons are, just like when we talk to our judges, we know what they want to hear. Same with the prosecutors. So fantastic. I'm actually going to try that on one that I've got right now. Adjudication.
If you happen to get a remand, just know that there are AOC forms for the expungement process.
Yes.
There's a separate AOC form to expunge the DNA records that go along with that. So you need to fill out both of those, especially if you've got a prosecutor who doesn't know that exists. That might not be done properly if you don't do it yourself.
Yes. Because our prosecutors know all of it, right? Really well. Whoops, did I say that out loud? Adjudication is our guilt innocence phase. Disposition is our quote sentencing phase. Remembering, of course, the purpose of juvenile court. We can talk more about it when we throw you your party for getting it remanded back. But for the time being, any questions? Fantastic.